Who can file for a construction lien? The availability of construction liens is provided to those who contribute physical labor or provide specialized materials to a permanent improvement on a specific parcel of land, generally possess the right to file a construction lien. This includes primary contractors who deal directly with the property owner, as well as subcontractors and sub-subcontractors who occupy lower positions in the contractual chain. Registered professionals, such as architects and engineers, are also typically entitled to this protection if their services directly facilitate the physical construction or alteration of the structure. The core requirement is that the work or materials must be lienable, meaning they are incorporated into the project or used to advance the physical realization of the development. Suppliers who deliver equipment or fabricated components specifically for the site are similarly eligible, provided those items are destined for use on that particular property. Parties who offer purely administrative or financial services without a direct physical connection to the construction site are generally excluded from filing a lien. Lenders, mortgage brokers, and investors provide the capital necessary for a project to proceed, but do not perform the type of work or improvement defined by construction law. Similarly, lawyers and accountants who provide professional advice regarding the business or legal aspects of the development do not have lien rights. These entities must rely on their contractual agreements or other forms of security to ensure payment, as their contributions are considered intangible. Because their services do not physically increase the value of the land through labor or materials, the statutory remedy of a lien is unavailable to them. The distinction between a lien holder and an excluded party often hinges on whether the materials or services were actually used for a permanent improvement. A supplier who provides general inventory to a contractor without a specific destination or project in mind cannot later claim a lien against a particular property. If equipment is rented but never actually reaches the site, or if the materials are diverted to a different project, the right to file against the original land is lost. Similarly, individuals providing maintenance services that do not constitute a lasting improvement, such as basic janitor work or recurring landscaping tasks like mowing, are typically barred from this process. The legal framework requires a nexus between the contribution and a lasting physical change to the real estate. Strict adherence to procedural timelines and contractual status determines the final eligibility for filing a claim. A person who otherwise qualifies as a lien holder will lose their right to file if they fail to register the claim within the mandatory period following the completion of work or the delivery of materials. Furthermore, individuals who are not properly licensed to perform specific regulated trades may find their lien rights invalidated depending on the governing regulations of the industry. Even a valid contributor can be stripped of this protection if the underlying contract is found to be illegal or if the party has previously waived their rights through a signed release. The ability to file is therefore a combination of the nature of the work performed and the diligent observation of formal filing requirements. To learn more about our law firm's construction lien legal practice, visit our website and contact our law firm to schedule a confidential consultation. Thank you.